You are Namus Perez Cajax?
Yes.
Sir, you were charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do...
Right here is where this gets real. Probable cause isn't a conviction. It's the judge deciding whether the case is legally strong enough to move forward. But notice how fast we shift from traffic accident to potential jail time. This is how minor cases quietly turn serious.
Complaining witness advised that a black vehicle disregarded the stop sign. Complaining witness advised the vehicle stopped briefly before driving away. A witness saw the crash and took a picture of the license plate. Officers ran the plate and found the defendant was the registered owner. Officers made contact with the defendant, and defendant agreed to meet officers at scene of crash. Defendant admitted to being involved in the accident. He advised that he is the owner and the only driver of the vehicle. The defendant advised the officers that he did not see a lot of...
This admission is huge. He admits he was the driver, admits involvement, and admits leaving because he thought the damage wasn't serious. That's a common mistake. And legally, it doesn't matter what you think. The law decides whether damage is minor, not the driver.
United States citizen.
No.
Are you in this country with or without permission?
Without permission.
What happens if you go to jail, Mr. Perez?
Si usted va a la cárcel, señor Pérez. I don't know.
Are you in this country with or without permission?
Está en el país con o sin permiso.
Sin permiso.
Without permission.
I want you to think,
Yo que piense.
what happens if you go to jail?
Bueno, si voy a la cárcel, pues voy a cumplir con lo que diga el juez.
Well, if I go to jail, I'll comply with what judge says.
You're not in this country with permission.
Está en el país.
Immigration sweeps the jail on a daily basis, every 6 to 8 hours. If you go to jail, in immigration...
This is the moment immigration consequences enter the courtroom, and it changes everything. Jail isn't just jail here. For undocumented defendants, even a short stay can trigger ICE detainers, turning a misdemeanor into months or years of custody. This is why judges hammer conditions so hard.
2, you do not have a Texas driver license, so you are not allowed to drive. I am having you sign a promise with me today. This is an affidavit that you're not going to drive, and I don't care what is going on in your life. I don't care if you need groceries. I don't care if someone has to go to the hospital. I don't care if Bambi gets run over and needs to go to the hospital. You get into a car and drive. You can be doing a substantial amount of time in jail. Do you understand?
¿Entiendes?
This is an affidavit you're signing, promising me that you're not going to drive. I'll have you first sign this. After that, I'm going to get you to Victoria. We will have you sign a reset. We are going to get you out of here. You need a lawyer. So we are going to give you time to go hire a lawyer. I'll have you sign the reset, and then after that, you'll be free to go. When you come back, please have a lawyer. Do not pick up any more criminal cases. Do you understand? Okay?
Thank you.
I can't tell you how upsetting it is, the way that you've treated us. It's absolutely just, your case is 1,580, it's nearly 1,600 days old, and you want them to just, and you come in shorts? Really?
Now the tone flips. This isn't about the charge anymore. It's about respect. Courtroom decorum matters more than people realize. Judges see attire as a reflection of seriousness, accountability, and effort. Whether fair or not, first impressions in court absolutely carry weight.
You should know how to dress in a courtroom, considering that your case is nearly 1,600 days old. How many years is that, Mr. Pony?
4 years.
You have until next Monday to get the mitigation packet. done. If you don't have it done, then you will get an immediate 10-day trial setting. And I don't care who's got what. State, get ready for trial now, please.
Yes, Judge.
Get everything that you need to get now, because I'm fast tracking this to trial. And I don't care what came this, what came that. Jesus came down to prevent you from doing, I don't care. You have until Monday to get the mitigation packet done. And if you don't have it, then you will either accept the plea bargain from the state or you will get a 10-day trial setting.
Yes, sir.
Do you understand? And if you come back again in Schwartz, I can't tell you the level of disrespect that shows, not to mention the fact that your case is 4 years old. I mean, it's a double kick in the ding-ding to us, really. And you ought to be ashamed, because that's not the way someone acts. Right. Take a seat for me. We'll be back. Good morning, Mr. Hodges. Could you run an NCIC on him, please? What all does he have open elsewhere?
Yes, I'll run it right now.
And then if you can refresh my memory with regard to our case as well, please.
Yes, sir. In regard to open cases, it appears in Galveston, he has an open UCW, DWI, and a collision involving damage to a vehicle equal to $200.
It says an FSGI, DWI, and a UCW.
Yes, Judge. And then in regard to this case, the officer responded to a criminal mischief and made contact with the complainant, where the complainant stated he woke up and realized his tree had been ran into. He checked the surveillance and observed the defendant's motor vehicle colliding into the tree, traveling at a high rate of speed, and observed the defendant appearing to get out of the motor vehicle, walk in front of the vehicle, then get back in. And the officer later observed tire marks damaged on the landscape leading up to the tree, damage to the bricks around the tree, as well as damage to the tree itself, leading to damage approximately $200 for the grass and bricks and $2,500 for the tree.
And this is like, it's in the middle of the night, right?
Yes, sir.
Right. Okay. What would you like?
Judge, I'm asking to lift in the driving condition and the curfew. I get it, it sounds bad, but Judge, he's unable to work. He's an electrician. He works throughout the night sometimes.
Oh, I don't want you out in the middle of the night, Mr. Hodges. You have 4 open cases and you're out. You already were given one chance when you got on bond for those 3 cases out in Galveston. Now you've picked up another case in the middle of the night.
Are we able to lift the no driving restriction then, and maybe do 5 to 10 p.m.? It's just the 6 to 6 kind of interfere with his work schedule, like I said, but I understand completely not wanting to drive at night.
What's the curfew now?
I think it's 6 to 6.
It's 9 p.m.
Oh.
No, I don't do that bad. It's 9 p.m. to 6 a.m. What do you want, Mr. Hodges? I'm not giving you in the middle of the night. I'm telling you now, you have 4 open cases. 2, this is a potential DWI. So it's really a DWI and a second DWI. And you want me to let you out in the middle of the night?
Can we just lift the no driving restriction, Judge? Because it's daytime from,
Can you run his license?
Yes, Judge.
it's not eligible, but he has an ODO.
Yes, I'm saying not eligible.
He has an ODO license, Judge.
Did he have an interlock in his car at the time when he got here?
I don't believe so.
Then I'm not going to do it because he's supposed to have an occupational always needs an interlock.
It may have.
You're
Judge.
you're violating your,
But did you have an?
you're supposed to have an interlock as part of the occupational license. You're in violation of your occupational license,
It may not have required that, Judge. Because, but I'm not on the Galveston case. But
Show me, do you have a copy of the occupational license?
I have the granting of the occupational driver's license. The reason it didn't require interlock is because he had it prior to this. He got it for tickets that were unpaid because he didn't have insurance. He has current active insurance. I have the ODO right here.
Who gave it to him? Is it a JP court?
Yes.
Can imagine knowing that he has that open DWI in Galveston and knowing that he has now picked this case up here where it has an alcohol. I can't imagine that they're going to let that,
Right now it is still active. So are we?
I don't know how comfortable I feel with him driving. Are you Mom? Yes. Come on up, Mom. Come up, Mr. Hodges. Thank you so much for coming.
Thanks.
How's it been not driving?
Not enjoyable.
Blows, right? Good. Wonderful. Because I want you to understand, it is a privilege. It's not a right. And we do everything in our power here to ensure that we don't kill anyone on the road. Watch the news. Every day, someone dies on our roads because of an alcohol-related collision. It's disgusting.
This is no longer just law, it's personal. When judges speak from lived experience, sentencing philosophy shifts from punishment to prevention. The message here is clear. Driving is a privilege, and once someone shows a pattern, courts will prioritize public safety over convenience every time.
Because of what's going on with Galveston, and now here we have the same situation here. They didn't charge him with DWI here, but very well could have been. And so the idea is to get you to appreciate it, to really feel the pang of not being able to drive, because I want you to realize it is an absolute privilege, and it is a great privilege. And to live in a city this big without the ability to drive really, really blows. That's just it. And I don't know if you really appreciate it. You coming up here and just telling me, oh, I'm so sorry, I'm hurt. That's not enough. I need to know that you really do appreciate the fact of how big and powerfully awesome it is to drive. I'm not ready yet to let you drive. I need to see some kind of proactivity showing me that you really appreciate being able to drive. But as it stands now, it's been 30 days since he's had this case here open. He's got the 4 cases over there. And I can tell you now, the judge that granted that license, if that judge now knows all these cases are open, I would bet my pinky toe that judge would revoke that license now. Because I don't think any judge wants their name on a license with that kind of baggage to it. So I'm sorry. If you need more time at night, I'm happy to give you a little bit more time past 9 o'clock.
It's not so much, excuse me, it's not so much the night, it's where he works being an electrician. He has to be there earlier in the morning, so.
Okay, I'm happy to work with you. You want 5 in the morning? What time do you want?
5 would be better.
Okay, done. I'll give it to you. Show me that you appreciate the fact of driving.
How do I do that?
Use your imagination. Be creative. Ingenuity goes a long way, Mr. Hodges, but you coming up here and tell me, oh, I'm so sorry, does nothing for me. Actions speak louder than words, and it's only been a mere 30 days since you picked up this case, and not to mention all those other cases that you have in Galveston County. So you are traveling far and wide, and the danger to the public is far and wide as well. I don't want anyone to die under my book, and I don't want anything under my name with that kind of, I don't want that kind of baggage in my life. I have a hard enough time sleeping as it is. Show me, and then we can talk again. But I really want you to appreciate it, and I don't think you do so far. Okay, thanks. All right.
I'm approaching on Noah Biza.
Okay,
This is set for bail review today. It was also set on Friday and it got rolled to today.
She's here.
She is here. Her bond was revoked and raised last week due to her picking up a criminal trespass. So she does have 2 ankle monitors on right now, and we would just be requesting that one of those come off. Obviously, she knows that she's not supposed to be within 200 feet of Stereo Live, which is the bar that she was trespassing at.
what I don't want is I don't want her out in the middle of the night. And that's why we have that on. And I'm paying for everything, so nothing is going to come out of her pocket. Come up, Ms. Bison. She had the open DWI. just doing whatever she wants to do. And now she picks up another case out in the middle of the night. Nothing good happens at 2 a.m. And I don't want you
This
out.
is a textbook probable cause collapse. The law requires intent to cause fear, not just angry words. Without clear evidence the complainant feared imminent harm, the charge can't stand. It's a reminder. Emotions don't equal elements, and courts still have to follow the statute.
Issue. I know that and I'm sorry that it's uncomfortable. Well, I'm not really sorry, but actions have consequences. You now see, and I'm going to tell you, you violate conditions again. Get ready for that bond. It's going to sprout legs. It's going to be, you understand? Show me after a while that we can trust you and perhaps we can talk. But you're just now getting out of jail after violating conditions over and over. Thanks.
Understood.
Okay.
Thank you.
So you're now out of jail. You have a lawyer. It is your responsibility to stay in touch with them, and they will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, you're ducking and dodging, you pick up a third case, violate conditions again, there goes the bonds. Do you understand? Okay, stay in touch with them, and they'll tell you when you have to come back to court. So I'm going to waive the appearance so that she's whatever you guys need.
Thank you. And she did just complete IOP, and then she is planning to enroll in SOP prior to potentially entering into any other program that the court might have available. So,
yeah, it's up to you guys, whatever, I'm just here. I just want to make sure that she's not out and about and continuing to party. According to her, she wants to go to school for this. She wants to go to school that, if you really, how old are you, ma'am? You have something that I can't buy. I have money, right? I've got a ton of money here, there. Steven's got a lot of money. But you got something that I can't buy. You got something Bill Gates can't buy. You got something that Jeff Bezos can't buy. Do you know what that is? No. Age. And the reason is, all those guys would pay an arm and a leg to be able to take back time to have age. But what matters is what you do with the age that you have. If you do nothing, it's a complete waste. If you're going to school, and if you really care about the future, then you're going about it all wrong by continuing to pick up cases, partying, going to a bar and refusing to leave the bar because I've got to wait for my drink. This life is a journey. It can be a great journey, or it can be a rotten, miserable journey. And as a young woman, you should never, ever have to realize or depend on a man. You should be getting your education. You should be getting degrees. You should be getting knowledge so that you never have to rely on a man. Men suck. Men are dogs. And you need to be able to rely on yourself, because if a guy says that they're going to take care of you, great. But one day they may never be there. One day they may take flight. And if you don't have an education, if you don't have a career, if you don't have knowledge, you'll be destitute, penniless, always dependent on a man. Don't. Become a strong woman with knowledge, because then that life becomes a great life. Because this life is only about one thing. This. The almighty dollar. And if you don't have this, you ain't got shit. You know what I mean?
Yes, sir.
So get your knowledge. Stop picking up cases. Once that age is gone, don't come back. Thanks.
Your Honor, my client does have class from 5 to 9, 6 to 9, my apologies. And I know she has a curfew right now that is imposed. Would the court be amenable towards pushing that?
Absolutely. Show me proof that you're in college or that you're in class and that the class goes at that time. I'll happily give you time to go home. Of course. Yeah. But I'm not going to take your word for it. Show me that you're actually enrolled. You got like either a syllabus or whatnot, and then I'll, of course, am always amenable to working around a schedule for school, of course. Just show me and then we'll do it. Please.
Thank you, Your Honor.
Of course.
May we be excused?
Yes, ma'am.
Thank you.
Ms. Wickenhoffer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watch it anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222, you already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11, I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations. This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I am asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So I don't think I can. Show me where you think I can, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says I can give you a non-disclosure, and I can tell you, Ms. Wickenhoffer, I love it, and I've told you this before, I love it when people try to better themselves, right? If I can, I will, because I'm always about trying to make someone's life better, right?
Yes, sir.
But I have to follow the law. I can't just say, okay, I can't just rubber stamp and do it just for the sake of doing it. There has to be a law, because if not, they appeal it and I'll get overturned.
Yeah, I think it was the points I said, because I was under a certain amount of alcohol in my system.
That doesn't, what matters is the ultimate result in the case. Did you plead guilty? Did you do a probation? Did you do a deferred? I think that the legislature even now made deferreds available for certain types of DWIs so that people don't get convictions, right? But, and we never do them, right? But you can, right? And it's surprising that no people do deferreds on DWIs.
Traditionally in Harris County, Judge, we don't even offer deferreds on DWIs.
But theoretically, if you go without an agreed recommendation, we could, and I think that we may have. I don't remember, but
so they don't grant deferred here then in Harris County.
No, you can. It's
You have to pay more money, so it sounds like.
No, it's not about money. It's about, there are other options that are better.
Okay.
For some. So
I think that's probably why I didn't do it, because they didn't give me the option to.
We always do, though. Every single case. I talk to every single person that comes up here, and I make sure, hey, look, you're making a lifetime decision. Are you sure that you want to do this? Because it's not Target. You can't return it once you do it.
Yeah.
I literally, every person I scrutinize, micromanage. That's why we're still here. It's 1:10 when most judges are gone by now, right? I really care about everybody that rolls here, and I want everybody to get the great result. And I don't know what was happening in your life at the time when this happened. Why did it end up like this? Was there something other? Did you have other charges elsewhere? If you can show me in the law that I can then let's talk. That means you got to get it,
In writing.
No. Go through the actual, this is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures, who is eligible for them. You have to read it, you got to digest it. You definitely are not, I don't think I can't give you legal advice, right?
Yeah, I understand. It's something to do, but I don't know. I just want something to be done. I just don't know what can be done. It doesn't sound like anything, which really sucks for me, but.
It does. Yeah, and the thing is that I even tell people that, within a certain amount of time, if you get buyer's remorse, within 30 days of doing something, we've really reopened cases for people who get buyer's remorse, but here, the case is 5 years old. I have no jurisdiction, even if I wanted to reopen it, to do something, I can't. The only advice.
Any service I can do, like any extra thing I can do?
What I would do is really go to a lawyer. You're going to have to spend a little bit of money. Go to a lawyer and fine tooth comb non-disclosure law.
Okay.
And see, is there an out? Is there this? Is there that?
Mm-hmm. Just ask questions. Okay.
You may have to hire a lawyer to really dig into it to see what you can do. Okay. But I can't give you legal advice. I can't sit there and comb the code with you to see, is there a provision that would get it? Because there's so many little nuances here and there. Right. I mean, even so much as a 0.15 or above or 0.15 or below, how long it'll suspend your license versus this, there's just so many little nuances. I'm so sorry.
That's okay. What was that book called again?
The Code of Criminal Procedure.
Okay. All right.
So,
thank you.
Google Code of Criminal Procedure, Texas non-disclosure, and even if you do that in Google, you'll have so many other lawyers' sites. Read through all those.
Okay.
But I don't think that I can. Once you plead guilty, that's it. That's why I caution everybody, when you take the easy way out, when you do something like this, it's a lifetime thing.
Yeah, I understand. Thank you.
Sorry, Ms. Wickenoff. Hi, Ms. Burnett.
Hello.
Okay, so it looks like you're wanted. Bye, John D.
Take care.
So I would assume, what are the classes?
Decision making, anger management, judge.
And anger management, okay. Have you done any of the classes now?
I'm back in Beaumont since this case has occurred. My probation sent me back. So they're gonna have me doing thinking of a change and completing my community service and doing inmate mark. So that's all things I have to do in the probation.
This case, or are you on probation?
I'm on probation.
She's on probation in Jefferson County, Judge, but in addition to that, this case, she's already done an anger management class that she's brought to my office last week.
Mm-hmm.
But now the state's offering, in addition to that, effective decision making 20 hours for it to get dismissed. So I'm not sure if the community service she does while on probation can be used in conjunction with this, but I'm sure we can work something out.
I'm okay with that.
Okay.
I mean, have you done the community service yet?
Yes, I have done some of my community service.
Okay, then I guess make sure that Michael is okay.
Sure.
I am, but you got to understand, if you're on, is it felony or misdemeanor probation?
It's a felony probation.
I mean, self-control. I would say 90% of the people that are in jail now are for one reason only: self-control. They react, they act without thinking and say, if I do this, what's going to happen? If I say this, what's going to happen? And then you end up back in jail, you pick up a new case now, and you're on felony probation. Jefferson County is a really tough county. They don't toy around like here in Harris County. You violate over there, they're gonna lay you out. You understand that by pleading guilty to this case now, they can revoke that probation resulting in further confinement.
But I'm not pleading guilty. I gave her all the evidence.
That's right, we're not doing a plea.
Right, Judge,
Yeah,
we're not
So,
entering a guilty.
but at some point, you gotta understand, they're not gonna continue to bend over backwards to help you.
That's why
Right.
I tried to move back so much away from my family. Because that was the problem.
You have to say anything.
Well, self-control. It takes two to tango, right? You get into a pissing match with other people, you get into a fight. Don't matter. Everyone's going down. Just think about that. Self-control. All right, so how long is it gonna take you to get all this stuff done?
Right now, they got me looking for a job out there. I have an interview today. So hopefully after Thanksgiving, because everything's gonna be shut down probably tomorrow
Well, I
or.
don't wanna, set you up to fail. I mean, your case is old, but we need to give you enough time that you can get it done.
Can we do the first or second week of January?
That's a long time.
Because, but I know that with Christmas falling right behind Thanksgiving, if she gets it done before, then I can
My
always.
fear is that we get the Christmas, oh, this, that, then nothing gets done. We're here in January and then nothing's gotten done. I will give it to you, but I'm going to tell you now, if you don't have it done, I will carry you day for day until you have it done. I'm literally will reset you Monday to Tuesday to Wednesday to Thursday to Friday, and then to next Monday until you have it done. Your case is 212 days now. We're giving you another 40 days now. You got to have it done. And if you don't, I'm telling you, I'm going to roll you day for day until you have it done. You understand? It's not hard. Everything can be done online.
She's pretty proactive. She's come to my office often and brought me evidence and proof of her classes. So she's doing everything she needs to. And
It's a sweetheart deal. It's a sweetheart deal. Work it. All right? Self-control. All right. Good luck, Ms. Mitchell. All right. Thank you. All right, good morning, Mr. Houlihan. So you understand that you're entering into a very serious probation. We take it seriously, and if you continue to, if you violate, at this point, I mean, we can put you in a rehab facility, right? So just no alcohol. No alcohol from any source. That's all we're asking you to do. Stay out of trouble. If you don't have a license, don't drive. These probations are typically pretty easy. All you have to typically do is 2 classes, stay out of trouble, and don't drink. And as long as you can do that, then you're walking out of here, you know?
Yes, sir.
What are the conditions that we have, Shatoria?
Thinking for a change,
Okay,
DWI education, 2 victim impact panels, TRAS, random urine analysis, no refusals.
what that means is that if you are pulled over and an officer asks you to submit a breath sample, you have to do it. If you don't, then you're in violation of this probation.
No drugs or alcohol. And the guardian interlock.
Do you have you've got the scram now?
Yes, sir.
So what we'll do is when you get your, is this license suspended, Alex? Do you know? Can you run it?
I don't have a vehicle either.
I'll run it, Your Honor.
Then you will need to get a portable breath test device. And when you do that,
The scram monitor? Okay,
I'm paying for it now.
Okay.
That thing's around $400 to $500 a month.
okay, honestly,
So as opposed to the handheld device, which is probably about $100 a month. So if you want to keep it, you can, but it's costly. And once you get on probation, I can't pay for it for you. You will be responsible for the fines and fees. You know, I can take off and I can reduce your fines and fees, but there's outside vendor stuff I can't pay for, like your DWI education class, you'll have to pay for that. It's $30, right? The victim impact panels, you will have to pay for that. TRAS, can I waive the fee? I'll waive your TRAS fee, which is around, that's what, $200? Yeah, so I'll waive that fee for you. But remember, this probation is not about the money. It's about you doing what you're saying you're going to do in the time that they tell you to do it. So there's a certain time for you to finish everything.
It's suspended.
Your license is not suspended. So one of the other things I want to do.
It is. He was suspended. There's an ALR suspension. There is a suspension.
Yeah, it is.
Yes, sir.
So we will, as part of this probation now, require you to get your Texas driver license. I want you to get it so that at some point you can become a legal driver, but you have to have insurance and you're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught, then that's a violation of your probation. Don't just do stuff. You get permission first.
Yes, sir.
Don't try to do and beg for forgiveness after the fact because it doesn't work here.
Yes, sir.
You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept the probation, you're stuck with it until you complete it or it gets violated. Now, the agreement that you're entering into is 180 days jail time to be probated for 18 months. This will now reflect as a conviction on your record. From now on, you'll be facing a minimum of 30 days in jail. No proverbial slaps on the wrist. You understand?
Yes, sir.
Do you have any questions?
So what, does that mean I can go, when do I go take the scram?
First, you get the portable device. When you get that, we will take that ankle monitor off. I want to know that you have something that's testing you before we just take that off. We're not going to take your word for it that you're going to go get it, you know?
Yes, sir.
But the minute you get it, let us know and then we'll take that off and then you can keep the other one. If you fail, if you pick up a new case, don't do your stuff, I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out in Orange and we're going to talk about if you violated or not. And if they prove it to me, you're looking at 180 days in jail.
Yes, sir.
Understand? Do you have any questions? How do you plead to the offense? How do you plead to the offense? Guilty or not guilty? All right. I will find you guilty. I'm not going to suspend your license. So just take care. You have the ability to get it back. What do you do for a living, Mr. Houlihan?
I'm in the process of, I need to take the Texas Health and Life Insurance exam, and then once I pass the exam, I'm going to be working for an insurance company.
How do you support yourself now?
Right now, living at home with my mother.
Stay there. There's nothing wrong with it. You know, I graduated law school. I still went and lived with my folks. Man, I lived with my folks until I was like 35. There's nothing wrong with it. I saved a crap load of money, you know, and you know, that's what you do, right?
And it's also,
there's nothing wrong with it.
Also work from home as well, so.
Great. Just take care, you know, work at home, stay at home, make a lot of money, keep a lot of money in the bank, and then you venture out. Don't do things backwards, like have a kid now, because that's, do you have any kids?
38 years without kids.
Well, perhaps one day you'll get blessed, but just do things in the right order, and then things will work out for you. I'm going to waive your supervisory fees, your DPS fines and fees and surcharges, meaning I'm taking off around $4,000 of fines and fees that you would otherwise be required to pay. And if you don't get a license. But I'm going to tell you now, if you come back here with another DWI, a second DWI, there's a surcharge of $6,000, not to mention court costs. So you roundabout leave here with about $7,000 in fines and fees. So if you want to get lit in the future, just don't get into a car.
I don't have any interest in drinking at all anymore, honestly.
Time heals all wounds, Mr. Houlihan. Say it again.
Talk to him about marijuana too, because that seems to be the problem.
Marijuana can be a DWI with marijuana as well. It doesn't have to be just, if you take too much NyQuil, what happens? Right. So it doesn't have to be just alcohol. All right. Good luck. Don't smoke weed. Don't smoke weed. Mr. Cope, how are you?
Amazing.
I'm sorry?
Amazing, sir.
I hope. I really hope. You know, you've got a lot of stuff going on, and wow. All resolved.
All resolved.
What happened?
I know it.
Everything got dismissed.
Everything's done.
So no more probation.
No more probation. I'm tired of that.
Did you learn anything? If you learn one thing leaving here today, Mr. Cope, patience. Patience goes so far in life. When you are confronted with someone who's an a-hole, exercise patience. You know, it don't matter. Even if you're right and they're wrong, with your record, if a cop rolls up to you, they will probably hard pressed to take your side because of your record, you know. But if you exercise patience, right, or walk away, if you see a situation that's getting out of control, it's really going to serve you well. You know, I cannot tell you how lucky you are, really, that you're with this. You were on probation for an aggravated robbery with the where was it, the arson?
Arson.
Yeah.
Your Honor, he took a 10-month jail on the MAJ for the arson.
Is that what it is? But he's got sufficient credit that you're probably walking out of here today, right, Mr. Cook? But what I'm saying is patience goes a long way. Even, you know, if you get into a pissing match with an officer, anyone that has a power of arrest, who's going to win? Right. Every single time. I don't care if you're right. I don't care if you're wrong. You're still going to get it. So just patience. Tuck your tail. And, you know, if you ever have an issue, come back to me and I'll help you too. If you ever need help, come back to me here and I'll do what I can to help you out. If you need, you know, shelter. I mean, I can't give you money, but you know, whatever. If someone's messing with you in life, come back to me. We can try to work it out somehow. You know, I can give you a lawyer. We can work things out somehow, some way. But patience, man. You know, it really goes a long way.
So I'm just serious. As you asked me what I've learned, I've started to let things go more than I did 2 years ago.
It's great.
I've started to just learn to let things go instead of, you know, someone does something that sometimes you just gotta walk away. Like I'm dead serious about that. I'm not joking.
You know what that's called, right? Mature. You're growing up. And part of growing up is the fact that you recognize, hey, shit, if I get into this situation, I'm not going to win. You get into it with them, you're never going to win. It doesn't matter. So just don't. Walk away. Come here. I'll talk with you. We'll hang out. Whatever we need to do. The other thing is this, is that if you're ever in a car, you smell like dope, you smell like alcohol, it's not going to go well too. You're pleading now to this DWI. This DWI is going to go on your record. Understand that from evermore, you get pulled over, you smell funky, it's not going to go well. You understand?
Yes.
You give up a lot of rights by entering this agreement, Mr. Cope. You give up the right to a trial, right to compel witnesses, testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country. You're giving up the right to appeal. When you plead guilty, that's it. I want to let you know one more thing. So what did he ultimately plead to?
So he ultimately pled on the MAJ for the arson. He pled to the 10-month state jail sentence.
So you pled to a state jail felony, or does he have a third degree on your record? Because I want you to understand that if you have a third degree on your record and you pick up a serious felony, the next time you could be a potential 15 to life case. So that's why I'm saying if you pick up a serious felony, it could be a minimum of 15 years. All right. How do you plead to the offense of DWI?
I plead guilty to driving while intoxicated.
I'll find you guilty. I'll send you to it. What are we doing?
3 days for 121.
So 3 days, 121?
Yes, sir.
121 days credit, Mr. Cope. I really wish you the best of luck, man. I hope you go out there, start working, killing it, making a ton of money. You know, really, that's what life's about, buying nice things, right? Get out there and make the world a better place, all right?
How come you know where your boat's at today?
No, I don't know.
Oh, sorry. I'm my bad. My bad.
Okay.
I'm sorry.
Hey,
You know what?
okay, you know what? I got to change it up, you know?
Okay.
But we're trying to look good for you. All right, my friend.
Thank you.
180 days. Driver license
And waive
suspension.
the.
Yeah, please.
Waive the, fee,
Of course, of course. Mr. D, I need. Good morning, Mr. Hunter. You were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were conducting a trespass investigation at a gas station in a high crime area where narcotic/gang activity frequently occurs. Officers observed the defendant's vehicle parked for approximately 30 minutes in front of a no loitering sign at the gas station. The officers approached the vehicle and observed a strong odor of marijuana. Officers then observed in plain view a handgun between the driver's seat and the center console.
All right, Mr. Hunter, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
No, sir.
You are not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
You're on probation or parole at this time?
No, sir.
You are now working your fourth case within the last year, your third gun case. Tell me, what do you do with yourself? Do you work?
Yes, sir.
What do you do?
I was a family dollar.
Do you work full time? How much money do you make a month?
$1,600.
I'm glad that you're working. I want you to continue working. Did you graduate from high school?
Yes, sir.
You did, great. Okay. Do you want to apply for an appointed lawyer?
Yes, sir.
Okay. No more dope. I'm going to test you. And if I find that you continue to smoke dope, it's not going to go well. Do you understand me?
Yes, sir.
I will test you 40 to 45 days from today. If you test positive, it's not going to go well between us. You stop now. Do you understand?
Yes, sir.
There will be consequence because it's the fourth case, and I'm ordering you now not to consume alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
Come on, forget an application. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Stephen to fill out the application. We'll have you sign a receipt with Victoria, and then we'll have you hang tight.
Will there also be state law conditions?
No, because I'm going to monitor him and make sure he's not using, so we'll just, everything will be withdrawn.
Next is page 10. Mumford.
Yes, ma'am. Did you say they found weed on him or no?
I don't think it was in her. I think it was in her room.
What is your last name, sir?
Mumford.
Page 10.
Thanks. Mr. Mumford, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 4th, 2024, officers were dispatched to a call at a parking garage in Harris County, Texas. Officers made contact with complaining witness who stated that she and her coworkers, including the defendant, were working inside the parking garage. And the complainant messaged the defendant asking where he was located, and the defendant suddenly arrived at the third level where she was located and began to yell and scream at her. The complainant stated he threatened to beat her ass.
Were they together at the same place?
They were on the same, so they both worked at the parking garage, I believe, and they were both on the same level. Like it was in person, the threat was made in person.
Did you say she was in fear?
I don't see that in the Dunes, Judge, but let me really quickly at the offense report. I don't see that alleged in the OR, Judge.
Mumford.
So the only thing the state would say, Judge, is our position is, I know it doesn't say that complainant said she was in fear for her life, but the charging instrument, it's not one of the elements we have to prove. We just have to prove that the defendant intended to place the complainant in fear of serious.
I don't know. Let's see. A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to place any person in fear of imminent serious bodily injury.
So, and Judge, just to remedy the issue, we checked the probable cause affidavit on the charging instrument. On the PC affidavit, it does say that she stated she was in fear for her life.
That's the only thing I want to know is she in fear? How do we know?
Yes, Judge.
Because a lot of people make these stupid ass threats all the time and, you know, it's just, tell me what it says. And does she say that she was in fear?
Let's see, it does say that the defendant came to level 3 where she was located. He began to yell and scream at her, threatened to beat her ass. She stated that this scared her and made her in fear of serious imminent bodily injury.
And where is that?
This is in the charging instrument, the PC paragraph.
That's just the charge. But I get it. That's just because they put that in the charge. Nowhere in the OR does it say that she's in fear. Nowhere else does it say she's in fear. That's just because they always put that on every information with regard to this.
I understand, Judge. And
yeah.
The only position we have is that it's not one of the elements the state has to prove.
I don't agree. I'm going to find no probable cause in your case. The only thing I'm going to tell you is be careful, you know, really. Words have meaning. Words can hurt, right? Pen is mightier than the sword. Words can hurt. So be careful, all right? Okay, take a seat, please.
All right, Judge, we have one Spanish arraignment, page 11, Perez, come on up.